Hello, and thank you for joining me for Managing Risk in Real Estate Contracts. My name is Wendy Adkisson. I have been a realtor here in Central Oregon since 1985, so 35 years in August in the business. And primarily my career has been spent managing large real estate offices. In addition, I've also served on the Real Estate Forms Committee since its inception in 1996. So I'm pretty familiar with the forms and pretty familiar with the things that can go wrong in a real estate transaction. So I'm here to hopefully help you avoid those things. For the record, I am not an attorney. I'm not giving you legal advice. I'm just giving you practical advice based on my own experience, my own interaction with attorneys, my time spent on the forms committee, and just experience. The moment that you write an offer on a piece of property or receive an offer on one of your listings, that is your first opportunity to get yourself in trouble. Our business is fraught with risk. So if we can reduce it from the beginning as much as possible, I think that's the best approach. The risk involves you, it involves your clients, and it involves the other agent, your managing broker, and the party on the other side of the transaction. So there's lots of people who can end up in trouble because of a mistake that you make or just not practicing good habits. Normally I like to ask my class who's in the room so that I can tailor my presentation to the experience level, but since I don't have that opportunity, I want to make sure that you understand that this is not a basic contracts class. This isn't Contracts 101. This is how to reduce risk when you're writing a real estate contract. So if you're looking for something that tells you what to fill in on all the blanks, that's a different class. This is all about writing a really good contract and reducing your risk in as many ways as possible. So I've told you a little bit about myself. I want to make sure that you know that despite the fact that I have been a managing principal broker for most of my career, you should be following the advice and instructions of your own managing principal broker, even if they contradict what I have to say here today. If you feel like you'd like that broker to get some clarification, they're welcome to call me. But in the end, it's their license that's on the line, not mine, if something goes wrong in a real estate transaction. So if you have conflicting advice, follow your managing principal broker's advice. You're going to need a copy of the OREF residential real estate sale agreement for today's class. We're going to use the residential sale agreement just simply because it's the one most frequently used. And all of the other forms are derived, all of the other sale agreements are derived from the residential sale agreement. There's just some tweaks made for the type of property on the other forms. So the vacant land, for example, doesn't have reference to seller's property disclosure because it doesn't apply. For the most part, though, the clauses that are in the residential sale agreement are in the other forms as well. We're going to talk today about the difference between technically and legally and realistically and practically. So the forms say something very specific, and they are technically and legally enforceable as they're written. However, the way we actually do business is a little bit different than the technical aspects of the residential sale agreement or any of the sale agreements. So we'll touch on, you'll hear me go back and forth. Technically, this is what you should be doing, but practically, this is what really happens. So we'll talk about those differences. Want to make sure you remember you should always be following your client's instructions. They are your fiduciary. They are the person that you must listen to. It isn't your decision. We are only here to advise. So I see lots of agents get in their own way by making decisions for their clients. We should be giving them our professional input and then letting them make the decision and following their advice and their direction, provided it's legal. These forms, all of the OREF forms, are designed for you, to protect you and to remind you of items to consider in each transaction. They are designed by realtors, reviewed by legal counsel, and prepared for you specifically. So I hope you can appreciate the amount of thoughtfulness and consideration that went into creating these forms, because there is an awful lot of work that goes into the creation of the forms. And by the way, if you're not familiar with it, there is a website, orefonline.com, where you can give input. If you don't like the way a clause reads, or you think something's missing or should be changed, you can give input, and the committee literally looks at every single suggestion and takes a vote on whether it should or should not be incorporated into the form, trying to follow the 80-20 rule. We also need to remember we are not attorneys. Like I said at the beginning of this course, I'm not an attorney. You're not an attorney either, which I think is awesome, because we are not in a win-lose business, which is what attorneys do. We are in a win-win business. Everybody wants the same outcome in our transactions. We want a closing. The realtors want a closing so they can get paid and serve their clients. The clients want a closing because they're buying or selling. So we tend to take an adversarial position when things start to go sideways, which is just so unnecessary, because the reality is we all want the same outcome. So let's talk about some of the risks that are out there. Have you ever had a disagreement with another agent and their client over a transaction? Have you ever had that disagreement escalate to where you had to go get some advice from your managing broker? Have you ever had it escalate to the point where you needed an attorney to have a conversation with? These are kind of the steps of what happens when things start to go sideways. Have you ever had the disagreement escalate to the level of mediation? So mediation is an opportunity for the parties to sit down and be heard and hopefully resolve the situation before it has to go to arbitration, which is the next question. Have you ever been in arbitration? And again, I usually teach this class live, and it's interesting to see how few realtors have actually been all the way to arbitration. Most of you will have a situation where you have to talk to your managing broker at some point in your career, and probably an attorney. If you're doing enough business, you're going to end up in that situation. But if you can avoid arbitration and settle things in mediation, you will be ever so much happier. Did you know that the Oregon real estate sale agreement forms include a requirement for claims that meet the small claims court guideline? They must be heard in small claims court. So depending on the county that you live in, most of our claims are going to be heard in small claims court. The current small claims court limit for Deschutes County is $10,000. Most claims are less than $10,000, so you're going to end up in small claims court if you have a dispute. All of the sale agreements have a mandatory arbitration clause for claims that exceed the small claims court limit. So there's no option to go to court except for small claims court. Then we advance to arbitration. And there is also a requirement that the parties mediate first, because mediation resolves things. Guys, don't discount mediation. It is hugely helpful. That's why there's a penalty in the forms. If the parties refuse to mediate, then they will be penalized in that they cannot claim attorney's fees if they prevail in arbitration. So if you refuse to mediate and you actually win in arbitration, then you don't get your attorney's fees reimbursed. You can't even make a claim for it. So it's worth mediating. Did you know that the Central Oregon Association of Realtors offers mediation service for disputes involving realtors? So we don't mediate buyer-seller disputes, but if a realtor is involved, then the association will mediate that. The association also offers arbitration services for realtor-to-realtor disputes. So no client arbitrations, those go to the Portland Arbitration Service, or Arbitration Service of Portland, but they will arbitrate realtor-to-realtor disputes. They offer hearings for the NAR Code of Ethics violations. So if you are accused by another realtor or a member of the public or a client of violating the Code of Ethics, then our association will hear that case. So now let's talk about what you're responsible for. the myriad of ways that you can find yourself in trouble. First off, you're responsible for protecting your client, right? You have that fiduciary obligation. You are responsible for protecting yourself. No one's going to do it for you if you don't protect yourself. You also are responsible for protecting your managing principal broker, whose license is on the line for everything that you do. So if you get in trouble, they get in trouble. And your company, because of course the company is run by the managing principal broker. No managing principal broker, no company. You're responsible for completing the form to the best of your ability, and you should be pretty proficient at this, guys. You're responsible for recognizing potential risk. You're responsible for taking action to avoid that risk once you've recognized it. You are responsible for communicating all potential problems to your managing principal broker as soon as you're aware of them. Again, remember, it's their job to help keep you out of trouble, and my best guess is if you were to go read your independent contractor agreement right now, which is the legal binding agreement between yourself and your company, it very likely has a provision that says only your managing principal broker can make decisions regarding settling claims or resolving disputes. So you need to involve them. And you are responsible for resolving issues that arise in a positive and constructive way. Nobody wants a big bully in the middle of a dispute. You're also responsible for cooperating with others to resolve issues. I think one of my greatest disappointments in our industry is the immediate suspicion that comes to mind for realtors about other realtors. Oh, I bet they did this, or I bet they did that, instead of always expecting the good in others, and the willingness to be abusive to each other, to be condescending or rude or not return phone calls. So be cooperative. Settle issues cooperatively, communicate, have conversations with each other. So, what risks do we face? Here are the things that can come up. A dispute between the buyer and the seller. So, buyer and seller disagree because buyer found out that the home is smaller than the listing square footage says it is. As soon as they start disagreeing, I promise you will be included. I promise that no buyer and seller says, oh, it's not the realtor's fault, it's only the seller or the buyer's fault. You will always be included when things start to go wrong, so be prepared for that. You could also have an ethical claim filed against you by one or more agents or by a buyer or seller. You can actually even have an ethical claim by someone who's not a client. I actually chaired a hearing for an ethics claim that was filed by a neighbor because the neighbor overheard the realtor talking to their neighbor who was selling their property and heard how abusive they were and that they were yelling profanities and being absolutely awful. And so they filed the ethics complaint even though there was no obligation to them whatsoever. So know that it can come from almost anywhere. We also face the risk of a legal claim against one or more agents by another agent or a buyer or seller. So they can sue us, small claims court, or file for mediation or arbitration. The one that scares me the most, the biggest risk we face is investigation and licensing sanction from the real estate agency. Guys, the real estate agency is not your friend. They are a consumer protection agency, and they are here to find fault with what we've done and hold us accountable if we make a mistake. So know that when you hear from the real estate agency, you need to be on the defensive and prove that you didn't do anything wrong. I always feel like you're kind of guilty until proven innocent. Okay, so with all this risk and all these people we're obligated to protect, how do we protect ourselves? Well, do things right from the beginning. Just pay attention. So many of the challenges that I've seen in my career on transactions arose because of somebody who just flat didn't do their job. They didn't read what was written. They didn't pay attention, and it got them in trouble. Follow the standards of practice for your area. Now, normally at this point, I'll get a question from the audience. What is a standard of practice? Standards of practice are things that are common in any particular area, and they vary from area to area. They even vary in Central Oregon from what might be common practice in Prineville may or may not be common practice in Bend or Redmond. And definitely what is a standard practice in Portland is going to be different from what's a standard practice in Central Oregon. For example, in Central Oregon, we recommend that our clients, if they are buying a home with a septic system, have that septic system inspected and pumped. In Portland, where they have very few septic systems, they're recommending a sewer scope instead because they have trees with roots that invade the sewer system. And so you can end up with your sewer not draining properly because of the roots from trees that we don't have here. We just don't have those big deciduous trees here, and we don't have to worry about those issues. So the only way to know about standards of practice, this is not something that's written anywhere, is by talking to your managing broker and talking to other realtors and getting familiar. And that's why the real estate agency prohibits us from acting outside of our area of expertise, because they don't want us to get our clients into trouble because we don't know the standards of practice in a particular area. So just be careful that, and you don't know what you don't know is one of my favorite sayings. So until you know that you know, talk to other agents, talk to your managing broker, and make sure you're covering all your bases. The resources provided by your company and your managing principal broker's expertise. That's great protection. Somebody who knows what they're doing, who has that, knows the standards of practice, has that background, has that experience that maybe you don't have. Remember, your managing broker sees everybody's transactions, not just their own transactions, so there's no way an individual agent can ever have the experience that a managing broker has. I have probably reviewed hundreds of thousands of transactions in my career. I've seen pretty much anything that can go wrong just simply because of the number of transactions I've supervised. We have the opportunity to appear in small claims court, plead our case. We have the opportunity to appear at mediation and attempt to settle whatever the issue is. We have the opportunity to appear in front of an arbitrator trained in real estate law to plead our case. We have the opportunity, I say that somewhat facetiously, to appear in front of the real estate agency to plead our case, which I highly recommend that you do if you're ever called on the carpet by the real estate agency. We also have errors and omissions insurance, which is a blessing and a curse. The blessing being, of course, we have an insurance policy to protect us if we do get sued or if we do end up being financially liable for something. But the negative side of that is the consumer knows we have that policy too, and it puts a nice big red target right on our backs. So those are our protections. And the first protection that I think is going to save you more than anything else is communication. Guys, communication will help avoid or clear up most problems. Almost anything you can think of will be resolved if you just communicate. Does anybody have a realtor that they can think of that comes to mind that they hope they never have to do another transaction with? We all do. Hopefully it's somebody different for all of us, but we all do. And most of the time, it just really is as simple as poor communication. We get frustrated when people don't return our phone calls. And it's amazing to me how many realtors don't return their phone calls. Communication will bring clarity to unclear situations. Talk to each other, ask questions, get information. It reduces frustration amazingly. I can't tell you how easy it is to blow things out of proportion because we're frustrated. So if we can keep the frustration to a minimum by just communicating well, that will help keep things from getting out of control. It also creates trust and understanding, right? That person that you talk to all the time, that is the person that you trust more. Okay, so let's talk now about contract law. You have to consider contract law when you're preparing and evaluating any contract. For example, you need to write clear and absolute contingencies, and we're going to talk about that as we get into the form. But I want you to understand that contract law applies to all contracts, and it's one of the first things that an attorney is going to look at when determining how to approach a case to take advantage for their client. So it will always come into play, and you should be familiar with the basic components of contract law. What makes a contract binding? What actions could be considered a breach of contract? What are the remedies for breach of contract, and how is the contract enforced? All of those things are included in our sale agreements. Contracts aren't binding until they are both signed and delivered. Remember that transmission is required to make a contract binding. We know what actions could be considered a breach. The buyer has all the contingencies in a sale agreement, and if any of those contingencies are met and the buyer terminates regardless, then they could be in breach. What are the remedies for a breach of contract? Earnest money, right, primarily, but there are others. And then how is the contract enforced? So we'll talk about some of those things as well. So regarding today's review of the sale agreement, I want you to know that I am going to try to follow the form as much as practically possible. I promise to try not to read the form to you. I know that's tedious, but there will be some areas where we will actually read the form. And I don't think that's all bad, because realtors just traditionally don't read. They don't read the forms. So it might be good for you to have a little refresher. There are some areas that naturally tie together that are not back-to-back in the sale agreement, so we will be skipping around a little bit. We'll primarily be going from front to back, but we will be skipping around a little bit. And let's talk about seller's property disclosure before we get going on the actual sale agreement. The seller's property disclosure is not controlled by OREF. It is published by OREF as a convenience to our members, but it is legislatively created under Oregon statute by the legislature. So only the legislature can change it. So if you have suggestions for the property disclosure, talk to your legislator. We can't make substantial changes to the seller's property disclosure form at the OREF level. When is a seller's property disclosure required? It is required, normally I look for feedback from the class at this point, but it is required on all single family residential dwellings of 1 to 4 units. So if you're selling an apartment complex, it is not required and it doesn't apply. But if you're selling a duplex, then the seller's property disclosure does apply. And it must be delivered by the seller or the seller's agent to the buyer. Now, what constitutes delivery? Posting it on a website for someone else to retrieve is not delivery. So just for clarification, MLS, all MLS is a website. It's just a data exchange platform. So posting the seller's property disclosure is probably beneficial for your client because the buyer can get a sneak peek, if you will. But it is the time for revocation of an offer doesn't begin until the seller actually delivers it to the buyer or buyer's agent. So you need to get that in the hands proactively, and the onus falls on the seller to prove delivery if there is ever an argument. So you need to have that email showing that it was pushed over to the buyer. For the sale agreement itself, we are going to start in the definitions section on page 8 because it's very important that you understand how we go through how we count days, how we figure out what's in the contract and how it's enforceable. So let's take a look at the definitions. There are a bunch of them. The first definition that I'm not sure exactly why we ended up deciding that this was important to include, but the singular means the plural. So if we refer to buyer and there are 2 buyers, Singular or plural is sufficient to be referring to all of the parties of the transaction. Number 2 defines agents and firms. And by the way, guys, like I said, we're at the bottom of page 8 under definitions and instructions. So we're now moving on to item number 3 at line 383. Time is of the essence. The reason that that is in there, that's a legal term, and it allows deadlines to be enforceable. So if we didn't have a time is of the essence in our contract, then somebody could argue perhaps that deadlines don't matter. Number 4, line 384. Delivery to you is the same as delivery to your client. So guys, don't hold on to documents. When you get it, your client is deemed to have gotten it. So if there's a period of time for them to accept or reject it, that time starts when you receive the document. So remember, you are your client's eyes and ears. You are like the client, other than for the purpose of making decisions. So when you receive a document, get that over to your client as soon as possible. Number 5, while you are the recipient of documents on behalf of your client, you are not a party to the agreement. So stop acting like it. I cannot believe how many agents refer to we when talking about their client. Well, we are not going to sign this. There is no we. You are not a party to this contract. This is an agreement between the buyer and the seller. And I want to make clear too, that's why commission discussions don't go in the sale agreement, because the brokerage fee is determined by the contract between the seller and the agent and the agency via the listing contract, right? So in a sale agreement, the buyer and seller can't agree to modify another contract that the buyer's not even a party to. So keep commission discussions out of your agreement. Item number 6. Know what a business day is? It means Monday through Friday, except for recognized state and federal holidays. So when you're counting days, know that holidays don't count, Monday through Friday does. Number 7, deadline times are local to the property. This was just added last year or the year before. And I'm glad we did add it, because when you really think about it, let's say you have a buyer who's in Oklahoma and he's thinking he has to sign something by 5 p.m. and his 5 p.m. is different than our time 5 p.m. So the one that applies is our 5 p.m. Wherever the property is located is the time zone that counts. Number 8, when we refer to the agreement, we're talking about every document related to the agreement. So you don't have to list those all out. You can say, you know, that the house will be painted blue within 5 days of acceptance of the agreement. You don't have to say acceptance of the agreement and any counteroffers and addendums and blah, blah, blah. Number 9, delivery is required for acceptance to be binding. So we talked about that just briefly previously. I can't sign and accept an offer and stick it in my drawer and not get it back to the buyer and claim that it was binding as of the time I signed it. It is only binding when it's delivered. Emails are the same as manual delivery. I'm not sure why we need that in our contract in today's world, since everything is almost done by email, but just so you know, emails are binding. Know how to count days. Number 11. I can't believe how many people ask this question, how many agents. The first full business day after acceptance is day 1. So if you get acceptance on a Friday, Monday is day 1. If you get acceptance on a Tuesday, Wednesday is day 1, provided those days are not holidays. The sale agreement is binding on the heirs of the parties, but it is not assignable, is what number 12 says. I think it's interesting if you think this through. First of all, it's not assignable. I can't say I'm going to buy it and then decide I'm going to hand this contract off to somebody else and have them buy the property. I would need the seller's permission for that. But if I die as the buyer or seller, then the contract is binding upon my heirs. Now that's legally and technically, remember we talked about this at the beginning, legally and technically, if I'm selling my property and my buyer dies, I can attempt to enforce the provisions of the contract with their estate. But realistically and practically, since we have a loan contingency and other things in the contract, it's probably not going to happen. So this is one of those things where, yes, technically it's enforceable. It's primarily more on for the seller side. If I'm the buyer and the seller dies, the heirs can't decide to do something different with the property and sell it out from under me. I can enforce the contract against the heirs, but just know that it is not very practical. If they are going to put up a fight, it's going to be a battle. Number 13, documents can be delivered in counterpart. So if I sign this document and you sign that document, we can put them together to create a whole. And number 14, contingencies expire at 5 p.m. on the date of expiration. So just know that it doesn't go to midnight of that day. 5 p.m. on the date of expiration is the end of it. And number 15 is a definition of notice, and that's the providing of a true and accurate copy of whatever it is that the notice calls for to be provided. So those things are important to know. Those are the definitions. If you need to point to something, if you're challenged on the number, when does the inspection contingency expire, you can point to the definitions on pages 8 and 9 in order to reinforce your position. So let's back up now to page 1 and the final agency acknowledgement. So the final agency acknowledgement is required to be completed in its entirety before either the buyer or the seller sign the document. The law says, statute says that the buyer and seller must be made aware of each agent's agency relationship to them at the time of considering the offer. So I have to know who represents me and who represents the other party. And I have to sign off on that even if I'm not going to agree to the offer. Make sure that all agents representing the parties are listed. Use an addendum if necessary. So what I'm referring to is in particular are teams. So let's say that Mary Smith is the buyer's agent who showed your listing. But Mary Smith works for Bob Jones, and he's got a team of 4 or 5 people. When she writes up the offer, she should be listing herself and anybody else on that team that represents the buyer as a buyer's agent in the final agency acknowledgement. Because the seller has a right to know who all the people are that represent that buyer so that they don't disclose things to them that they wouldn't have disclosed had they known. So we get ourselves into trouble sometimes not recognizing that if you know someone's on a team and you're writing an offer on a listing that is listed by a team of people, but the person in the MLS is Bob, only Bob's name should not go on there. You should include anybody on the team, and you may have to call to discover. It cracks me up how many agents aren't willing to pick up the phone and make that phone call just to ask the question, hey Bob, I know the MLS says you're the listing agent, but since you're on Mary's team, is there anybody else that also represents the seller? Just ask the question. If you fail to complete the final agency acknowledgement in its entirety, it can subject you to licensing sanctions. And license numbers are available in Rapatoni. Whoops, I haven't updated this slide. In Flex MLS, or they're also on the real estate agency's website. So I think everybody knows that by now. The license numbers have been required for long enough that we should all know where to find them. So let's talk about earnest money. I'll bet if I could ask for a show of hands that there are a large number of you listening to this recording that believe that the earnest money should be 1% of the purchase price. I know that because I review enough offers that say the offer price is $305,000 and the earnest money is $3,050. And I know that that means that agent has not received a good explanation of earnest money. So you know that earnest money is good faith money. It's the money that is at risk. Sorry, I forgot to move my mic a little closer. Hopefully you can hear me. The earnest money is the money that is at risk should the buyer breach the contract, should they fail to close, fail to perform. So only the seller knows what amount of earnest money is adequate. Only they can determine that. And it's going to vary from seller to seller and circumstance to circumstance, not necessarily based on the purchase price. Now, purchase price, of course, is some indication. You wouldn't offer the same amount of earnest money for $1 million property that you would for a $100,000 property. But in the end, it could be that the seller is going to be more damaged on the $100,000 property than they would be on the $1 million property. So I like to use extreme examples just to get my point across. So let's say we have a $400,000 house and the house is vacant. The owner has not had a tenant in it in several months. They finally decide they're going to go ahead and sell it. So they put it on the market and they own it free and clear. A buyer comes along, your average 45-day escrow, and on the day of closing, the buyer walks away. Worst case, possible case scenario. Seller's all ready to close to get their money and the buyer walks. How much has that seller been damaged? Well, certainly he is damaged and certainly he deserves some compensation. But he's not making, excuse me, he's not making payments on the property because he doesn't owe anything on it. Of course, that money is not working for him in other ways, so that's a factor. He didn't move out of the house. He didn't hire a mover and pack things up. He didn't move a family. He didn't move a tenant out. He wasn't damaged in those ways. So perhaps the value of 45 days worth of payment, were he making one, would be adequate earnest money. It's probably not going to be a huge figure because he hasn't been damaged extremely financially. But let's take the exact same property, only now there's a family of 5 living in that home. The seller has 3 children and possession is as of the date of closing, so they've got to get all packed up and moved out in advance of closing. And additionally, the fact that he's now sold his house allows him to accept a job in Chicago. So he has now booked a moving van to move his belongings across country and bought 5 airplane tickets to move his family across country. If that same buyer breaches and walks away on the day of closing, is this seller more damaged than another seller, the other seller that we discussed would be? Absolutely. He's got the cost of his mortgage, the cost of the plane tickets, the cost of the moving van, the agony of having moved his family out. You know he's probably put a deposit on another home, whether to buy or to rent. Perhaps part of that money is non-refundable. So earnest money can only be determined by the seller with help from the seller's agent. So when you're writing an offer and offering earnest money, like we are forced to do as the buyer's agent, you can only guess. And as a seller's agent, we shouldn't be passing over the earnest money and not spending any time on it with our seller in evaluating the offer. I actually had a seller who called me one time and was furious that they were only going to get $1,000 because the buyer had breached the contract. And it was about a $550,000 home, and we only had $1,000 earnest money that my agent had collected, and I'm not sure why we didn't get any more. But here I am on the phone with the seller, and she says, well, why is it only $1,000? And I said, well, it's because that's what you accepted, was $1,000 worth of earnest money. And she said, aha, now I know why your agent just skipped right over that part. And she came after us for damages because she accused our agent of not having explained to her what the earnest money was actually for. So it doesn't happen very often that earnest money is forfeited, but guys, know that it does matter that you have that conversation with your seller to avoid risk. Let's talk about non-refundable earnest money, because that's when I'll often hear an agent say, well, we'll just make them put up a bunch of non-refundable earnest money and then they won't walk away. I assure you, the more earnest money that is at risk, the more likely the buyer is to fight over it if they do end up having to walk away. So you actually create more risk by taking excessive amounts of earnest money. And non-refundable earnest money is tricky. It really is important that everyone understand what non-refundable means. Refundable, non-refundable earnest money shouldn't even be written up. So when we're writing a clause for non-refundable earnest money, make sure you identify how much of the money, of the earnest money, is non-refundable. Is it all of it? Is it part of it? Be specific to the amount. Why is it non-refundable? If you're sitting in an arbitration or a small claims court hearing and you're fighting over earnest money, the judge is going to want to know why that money was made non-refundable. And if there's no good reason, he's going to give it back to the buyer. So you've got to have consideration because of the extended closing, because of the fact that there were multiple offers, something that explains why we made it non-refundable. There has to be authority to release. If the money's going to be released to the seller before closing, make sure that the language includes that. Make sure that we explain what non-refundable really means, meaning clearly state that it's gone. Mr. Buyer, you are writing a check for the opportunity to get your offer accepted. And that unless the seller defaults, they're not going to get it back, because I promise you, when you end up in the courtroom, the buyer is going to claim they didn't understand what non-refundable meant. So make sure that you make it as clear as possible. Language similar to that the buyer understands that unless the seller is in default, that this money will not be returned to the buyer under any circumstances. And then regarding that, if there are circumstances under which the buyer would get their earnest money back, then it's not non-refundable. And that's probably one of my biggest pet peeves is don't make refundable non-refundable money. It's impossible. So if they're going to get the money back if the property doesn't appraise, then it's not non-refundable. It's just going to become non-refundable after the appraisal comes through. So trying to make sure you're careful with earnest money and that you at least have the conversation with your clients. Make sure the buyer or seller, whomever you're representing, really understands what earnest money is for. Now we're going to talk about seller financing. And the reason that we're going to talk about that is because if we're still on page 1 of the sale agreement, we've reviewed the final agency acknowledgement, we've got our offer, we've talked about earnest money, which is on line 40. The next thing a little bit further down from that is at line 43, we have to mark whether we're going to have a deed or a contract passed to the buyer at closing. And a lot of people immediately assume it's always a deed unless the seller is financing the property, in which case it's a contract. And that's not the case. It depends on the instrument in the seller financing. So it is true that if the seller is not financing it, 99.9% of the time, you're going to mark the deed box. But even if the seller is financing it, most of the time, they're going to use a note and trust deed, similar to what a bank uses in financing real property. And the deed is going to pass to the buyer at closing, and the seller is going to have a trust deed to secure their interest in the property so that they can foreclose if the buyer defaults. But a deed is still going to be transferred. The only time a deed is not transferred is if a land sale contract is used. And those are typically only used on commercial sales maybe, or apartment complexes, that kind of thing, because it requires an attorney to draft it. It typically is going to favor the seller, and the deed does not change hands at closing, and instead the buyer receives a security instrument proving that they're in the process of buying the property, but they don't hold title to the property until they've paid the seller off in full. So make sure that you're marking the right box depending on the type of seller financing. And then the actual seller financing verbiage is on page 3 at section 7. And because of Dodd-Frank, not all sellers can carry financing on their property. So the seller should speak with their attorney or their CPA or somebody to confirm that they are able to carry the financing if they're asked to do so and if they're willing to do so. And then if they are, you cannot give them advice on any terms, or you could be seen as having acted as a mortgage loan originator, and you could be subject to a fine because you don't have a mortgage loan originator's license. If there is no attorney or loan originator involved, then you must use the seller carried addendum and the seller and buyer advisory form for seller carried transactions to protect yourself. So Dodd-Frank says if you do any of the negotiations, if you advise them on interest rates or those types of things, you are acting as an MLO. If you're just filling in the blanks on a form, then you're not considered to be acting as an MLO. So OREF created a seller carried financing addendum. The form is a bit overwhelming, guys. Just be aware of that. And there is also an advisory form because it is a complicated process. And so get some help from somebody who's done it before or from your managing broker so that you fill the form out correctly and so that all the parties come to agreement on what the terms of the seller carrying the financing is going to be. So now let's move ahead to the top of page 2, sections 2 and 3. These two sections read the complete opposite of each other, and there's a reason for that. We are in the business of selling real property, which is the land and everything affixed to it. Those are fixtures. We are not in the business of selling personal property. So section 2 refers to all the fixtures that are included in the sale, and then there is the opportunity to exclude something on line 49 if you choose to. Section 3 are the personal property items that we want to include in as-is condition at no value, because lenders also don't loan on personal property. They are loaning on the real property, which is the fixtures. So I see lots of mistakes, weird things entered into these fields. For example, under fixtures, I often will see except tenant's personal belongings. Well, yeah, we hopefully knew that we were not buying the tenant's personal belongings. They're not a fixture. We don't need to exclude them. They are automatically excluded unless we include them at line 52. The other thing that I see that ends up being a challenge is that we're uncertain what some of the fixtures versus personal property are. For example, is a hot tub a fixture or personal property? If we were doing this live, I promise you half the room would say it's a fixture and half of you would say it's personal property. So to clear up any question, anytime you're not sure and you want to make sure your buyer gets that item, add it on line 52 under personal property. If the seller's agent thinks it's a fixture, no big deal. They'll laugh it off that you included the hot tub when that's already included because it's a fixture. But at least you got it for your client and there was no gray area. Same with things like invisible fencing. You know, is that a fixture or is that personal property? Make sure you just identify it and exclude it if you don't want it, include it if you do want it. The other thing too that I like to have agents include under personal property is all of the appliances and spell out each appliance: refrigerator, microwave, range oven, etc. Don't say per listing, because there is no place on the listing that says what appliances are included. So saying per listing, there are several fields where appliances could be listed. So safer to spell out exactly what it is the buyer wants. And built-in appliances are automatically included. A built-in range is a fixture. It's not personal property. But I don't know about you, but I'm not an expert on the difference between a slide-in range and a built-in range. So I'm just going to be safe and err on the side of caution and include the range and oven as personal property to make sure my buyer actually gets it. Remember that, again, the MLS is just a website. It's just an ad. It's the seller's first offering to you for items that they're willing to include or not include, the price that they're willing to accept, the terms that they're willing to accept. And then the buyer comes in with an offer. And anything that is not in that offer isn't included, even if it was in the listing, because the listing was just an ad. So if you want the refrigerator, make sure you write the refrigerator in, even if it says refrigerator under the comments as included in the listing. So make sure you protect your client. And understand that the listing, again, is just an ad. As related to the sale agreement, it has no bearing, and the court will not look at the listing and consider it to be evidence as to what should or should not have been included. It's no better than a flyer that says, here's what I'm willing to sell for and what would be included if you offered me this price, etc. I already said all of this. I apologize. Sometimes I get ahead of myself. I've taught this class enough that I know what I'm going to say and don't need to actually read the slides. So the rest of the slide just says what I've already